On Sunday, XRP advanced by 0.11%, partially reversing a 0.45% decline from Saturday, May 4th. XRP ended the week up 4% to $0.5305. There was no SEC versus Ripple case-related news for investors to react to on Sunday, May 5th. Nevertheless, investors awaited the SEC's remedy-related reply brief. The SEC must file the reply brief by Monday, May 6th, and a redacted version by Wednesday, May 8th. It may be the final court filings in the SEC versus Ripple case. After the reply brief filing, Judge Annalisa Torres will deliberate and rule on the punishment for breaking U.S. securities laws. In July 2023, Judge Torres ruled that Ripple breached Section 5 of the U.S. Securities Act for failing to register XRP as a security in sales to institutional investors. There is a significant disparity between the SEC and Ripple's expectations. In the remedy-related opening brief, the SEC asked the courts to order Ripple to pay a $876308712 disgorgement, a prejudgment interest of $198,150,940, and a $876,308.712 civil penalty. Significantly, the SEC also requested the court to prohibit Ripple from selling XRP to institutional investors. Ripple argued that a civil penalty should not exceed $10 million in the remedy-related opposition brief. Significantly, Ripple cited the three tiers of Section 20D of the Securities Act, stating, Tier 1, penalties for general violations. Tier 2, penalties for violations involving fraud, deceit, and manipulation, or intended and reckless disregard for regulatory laws. Tier 3, penalties for violations involving culpable mental state and resulting in direct or indirect substantial losses, or resulting in the significant risk of substantial losses to a person or persons. Ripple highlighted that it should be a Tier 1 case, saying that the SEC never accused Ripple of fraud, deceit, or manipulation. The opposition brief also referenced the dismissal of charges against Chris Larson and Brad Garlinghouse vis-a-vis reckless disregard of a regulatory environment. Judge Annalisa Torres must also decide whether Ripple continued breaching U.S. securities laws after the December 2020 complaint. The SEC justified its call for a $2 billion penalty and injunction by arguing Ripple continued to sell XRP to institutional investors. However, Ripple argued that XRP sales were to accredited investors or via ODL contracts. ODL contracts prevent profits and losses. There could be disappointment for investors hoping that the court ruling will end the SEC versus Ripple saga. The crypto community expects the SEC to appeal against the programmatic sales of XRP ruling. In the July 2023 ruling, Judge Annalisa Torres ruled that programmatic sales of XRP do not satisfy the third prong of the Howey test. The SEC must wait until the of its case against Ripple to appeal against court rulings. However, the SEC showed its intentions in August 2023 by filing a motion for interlocutory appeal. The court rejected the motion in October 2023, forcing the SEC to wait until the court rules on the penalties for Ripple breaching U.S. securities laws. The ongoing threat of an SEC appeal against the programmatic sales ruling remains an XRP headwind. XRP sat below the 50-day and 200-day EMAs, sending bearish price signals. An XRP breakout from the 50-day EMA would bring the 200-day EMA and the $0.5739 resistance level into play. A break above the $0.5739 resistance level could give the bulls a run at the $0.60 handle.